the smell of marijuana can never be used now. You're totally taking away that, something that's been a tool of law enforcement for decades. It can never be used now under this bill. Ever.
That they threw in psilocybin in the new decrim bill. They threw it in. Bill doesn't allow you to grow on farmland. It doesn't allow you to grow a crop, to grow a crop on farmland. A specific, that's against, it's unconstitutional under the New Jersey Constitution. This is 220 pages, 95,000 words of a mess. And that doesn't include the other two pieces of legislation that they introduced at the exact same time, that are moving at the exact same time and are considered part of the package.
Yeah, Michael, you mentioned being an attorney practicing for 20 years. You started the Hoffman Centers in Vineland, New Jersey.
Yes, I did.
Tell our viewers a little bit more about the Hoffman Center.
Well, I'm a true solo, which means that I am the Hoffman Centers. I don't have any secretaries. I don't have any other staff. It is me. I'm an attorney, and I do a lot of different things. But basically, my office is my laptop, and you know, it looks like I'm in a beautiful office, but this is actually the Supreme Court conference room behind me. So I like to look like I'm in somewhere important, but I'm actually just in my living room.
Looks actually
like most of America.
Yeah, that looks actually very legit. I thought you were there. Wow.
Yeah, it's a good background. I kind of like this one because if you know what this is, I think one of the most important rooms in our country. This is where all of the Supreme Court justices go to discuss Supreme Court cases without their staff, without anything else, all at once, you know, and this is where they make the decisions. So this room, I think, is one of the most important rooms in our country. A lot with regard to representing people in municipal courts about drug charges, especially in petty disorderly persons offenses on marijuana possession charges, and driving under the influence charges. That got me involved in the active practice of being in the policy area of municipal court law, which got me into the cannabis space, because frankly, it's got a criminal element to it. I mean, there's if you're talking about the criminalization and the decriminalization, if you're talking about expungements and clearing and the social justice, well, part of that term is justice, and you need to consider the justice system when you're doing so. So whether it's economic, criminal, or social justice, you need to have the face of the justice system, which has been considered the municipal courts in the state of New Jersey.
The decrim bill S2535. So is it necessary to pass this before the legalization legislation framework is put into place? Are citizens protected now? Can you go out and celebrate and spark a joint and smoke?
No. I'll give you the flat answer is no. The AG has been very clear about this in his directives, that prosecutors have the discretion to do something, whether or not to charge on it, but they don't have the absolute right to not charge, because currently it is illegal and remains illegal. That being said, and I think that a lot of our friends are very law happy and want to enter laws about everything. There are practical ways to solve this, and the 2535 I think has a lot of issues to it, and I'll just keep my comments on the issues to a minimum. But one of the biggest issues that I've seen with 2535 and decriminalization is that it only takes effect after a certain period of time, like every other bill that has to go through the legislature. Well, what happens in that meantime? That's why they're entering it, so that because they're worried about the legalization aspect and what happens in that space in between. Honestly, people need to come up with practical solutions that don't actually deal with law or, I mean, if lawyers have to think of practical solutions every day, that's a lot of what municipal court practice is. And I've suggested, a lot of people have suggested that the AG could come in and say no more prosecutions. He's not going to go do that, because he last year said, no, you have to keep prosecuting because this is the law that's on the books. What could happen, and I think what should happen, is realistically the best possible solution would be to talk to the governor's office and say, we need to, we see every day he comes up with a new executive order about the pandemic. Well, guess what? The biggest thing that's come out of the pandemic is we need testing facilities, we need testing sites, we need laboratories. We need our state police laboratories to be doing things that actually matter and not looking at pot cases, looking at testing marijuana, testing cannabis, and we certainly don't need them wasting their time on courts and doing that. So all the governor would have to do is, during this period of time of the pandemic, I hereby direct all state-related laboratories not to testify in courts in this state, that they are excused from testimony. At that point, under Crawford versus Texas, where you have the right to confront your accuser at the laboratory, it stops the prosecution. It stops it.
Oh, wow.
And that solves the problem.
Yeah, louder than people in the back. Absolutely.
It's like, it stops the case. I mean, and that's what we need to do. We need to stop these in between now and when the legalization comes through, and when the reparative issues of the legalization come through that are in the 220 some pages that it's going to end up being. There are repair issues and abilities in those pieces of legislation. They just need to actually do them. And I think that they could. And just give them the opportunity to do it, give them that time, and that time can be had by practical solutions versus legal ones.
Thank you for your insight. I want to transition into talking about how legalization is going to affect law enforcement. And I want to play a clip from the Senate Judiciary Meeting, and I want to just take a look at it, have us react to it, and get your opinion and insight. So I'm just going to pull this up here. I'm going to share my screen.
Shall not constitute reasonable, articulable suspicion to initiate a search of a person to determine a violation of this section. A person who violates this paragraph shall not be subject to arrest, detention, or otherwise be taken into custody unless the person is being arrested, detained, or otherwise taken into custody for also committing another violation of law for which that action is legally permitted or required. So the way I'm reading this is basically law enforcement, you're taking away one of their tools if they happen to occasion upon and they smell marijuana, which, hey, this is done all the time. This is how law enforcement's been trained for 50 years, that you may smell marijuana. They have controlled burns of marijuana for law enforcement. And so now we're saying that you can't go to court and present to a judge. Well, chief law enforcement officer, why did you, when you stopped the car, we smelled marijuana? Well, no, I'm sorry, that's not a cause. You had to have some other ground, some other violation of the law. Otherwise, it's basically a get out of jail card. So, is that a correct understanding of what's in the bill?
I don't believe, and I will turn it to the chairman if I just can. This is not to be a pretext for the stop. If the car is driving erratically, for instance, that will be the first indicator. The smell of marijuana cannot be the first thing, because you can't smell what's happening in the car unless you've already made a predetermination in your mind with set provision as to why you're stopping that vehicle. Chairman, if you want to, or Dave,
so basically, the smell of marijuana can never be used now. You're totally taking away that, something that's been a tool of law enforcement for decades. It can never be used now under this bill. Ever.
I think that's incorrect.
It says right here, it can't be. You have to have some other violation of the law.
It's going to be legal. What are you talking about? Of course, it can be utilized for the discussion and arrest for driving while intoxicated.
Well, you can't drive around drinking a beer, so now you're saying you can drive around smoking a joint.
You can, if you say it louder, doesn't make it true. Okay, that's not accurate. Utilization of marijuana within a vehicle is not permitted.
And if the cop smells it, it doesn't matter. Keep driving.
They can't search it. Yeah.
Stop it. I think Nick 𝐤𝐡𝒂🏐 hit it on the head at the end there. Unfortunately, he hit it on the head in a way that I think most of us should be scared about. I know that Senator Ruiz at the end of this, if you look at the 3 hours, I know Lefty left. If you know Lefty left and went out into the hallway, but I listened to the rest of the hearing. Senator Ruiz actually got up and asked as a point of personal preference for an apology from this senator for that yelling at her with regard to this provision. And the worst thing is he's wrong. I mean,
Yeah.
And he's scary wrong. Let's put it that way.
You can definitely hear and feel the disconnect.
Well, the problem is that he's wrong, but he's wrong in a right way. And that's where it really gets confusing. Let me see if I can put this in other contexts. We're not the first state to legalize. We're not the first state to come up with, to try to deal with the issues with regard to legalization and with regard to plain smell. And the smell of marijuana and what is it actually, or burnt marijuana, raw marijuana, cannabis, you know, these tools of law enforcement as to smell, you know, that we've had for 50 years, as he put it. What are we going to do with those? Well, we're not the first state to deal with that. And there are two different ways that the states have looked at it. I like to call them the Pennsylvania way, or the Massachusetts way, and the Illinois way. Massachusetts, when they came up with their first medical program, said, guess what? You smell marijuana in a vehicle, that is not a reason for a search. Because we have a legal program now, a person is allowed to have this legally. The smell of marijuana is not a reason to search a vehicle. You do not give up your Fourth Amendment rights under those circumstances. I need to give a little bit more background here because I feel like I'm jumping into it, you know, and this is an area that's really technical because it's search and seizure law. Under the Fourth Amendment, you have the right against improper search and seizures. Any search that is without a warrant is considered and presumed to be unconstitutional. Now, there are exceptions, and that includes the automobile exception. If you're in your car, there are certain limitations, and that's where the reasonable articulable suspicion question comes up, and the language is used in the statute, that marijuana shall no longer be reasonable articulable suspicion for a search that you violated possession of marijuana or possession of a controlled dangerous substance, because marijuana is no longer a controlled dangerous substance under the new law. That's what 𝐤𝐡𝒂𝒏 was saying. It's legal. It's not reasonable articulable.
Yeah.
It's like it's not going to be there for them to search for under 35 or 36, which is for paraphernalia. But where Nick 𝐤𝐡𝒂𝒏 kind of let the cat out of the bag a little bit is that it is a reason to search if you believe the person is under the influence. And that's where things get messy. In Massachusetts, you're not allowed to search, even if the person looks like they're under the influence. You're not allowed to search purely because you smell it, and not as a part of the search. However, in Illinois, if you remember how a legalization went in Illinois last year, you can think about it as they had a great New Year's party. that they legalized recreational use, and on the day before, the governor handed out pardons to everybody. Your pardon, everybody's pardon. Okay, so you've got complete legalization. Everybody's cleared up. Everything's cleared off of everybody's record. And then there's this case that comes in front of the Illinois Supreme Court in April of this year, where they said the cops came up to the car, smelled marijuana, smelled cannabis, and said, "Hey, we're going to search your vehicle." And in that search, found cocaine.
Oh, well.
Charged him with possession of cocaine.
Mhm.
And he argued, "I have the absolute right to have marijuana. I was, it's like I had the legal right to have it, and since we've forgiven all these marijuana crimes, what are you doing?" And they said, "Well, we didn't forget to keep driving under the influence on the list, and therefore we can search if we believe that you are under the influence." And that's where they're going to use it. Those police officers are just going to have to put
Okay.
in every single one of those reports that we believe that they were possibly under the influence, and therefore we searched their vehicle as a part of the stop. And that's going to be where they end up going. That's going to be the practical end around for cops. So the senator is right that these cops are going to end up doing these searches. They're going to end up looking for marijuana because it's going to prove their intoxication question. But does it? And that's the thing, is the actual existence of marijuana in the vehicle and the fact that they consumed it prove intoxication. This is one of the biggest problems with the legislation as it exists, and also the funding within the legislation. And I mean, I'm sure that I may be jumping the gun, but the DRE question, the Drug Recognition Evaluation Program, is the first thing and primary thing that's funded through this to determine if somebody is under the influence. That there is a program and a protocol that is used by the state police to determine if somebody is under the influence. This is not even required under New Jersey case law. The case law in New Jersey says that if the cop has enough standard training and experience to be able to say if you're under the influence of marijuana. That's it. As long as he, it's the old Justice Potter Stewart's pornography standard. He knows it when he sees it. Well, the cop knows that you're intoxicated when he sees it. It's not a volumetric. It's not an objective test. It is a completely and totally subjective test. If you look messed up, the cop can charge you and can convict you as long as it's in your system. They can do a blood and urine test, and as long as there's a presence, that's it. That's all they need under State versus Beeler. Now, they need a drug recognition evaluator for anything other than marijuana or alcohol. They can test alcohol and get a number, and we know, everybody knows about that. So is your .08 numbers and that's it. But marijuana doesn't work that way. We know that. I mean, science tells us that. Everything that we know tells us that.
Just like you said in the comments, they know how to test for presence. They can't test for impairment.
Yeah, exactly. They can't test for, they don't have a test for impairment. And right now, in front of the New Jersey Supreme Court, they have sent it down, the question on drug recognition evaluators, down to a special master to do what's called a Fry hearing. What a Fry hearing is it's a hearing that determines whether or not something is scientifically reliable, whether a test is scientifically reliable. You can't just go in and say, well, I put this into the machine and the machine popped out a result that said that there was something. You need to prove that machine is scientifically reliable. Well, the same thing, whether it comes to a speedometer, whether it comes to the Alka-Test machines, all those things have had to go through the Fry hearing standard. The DRE is currently undergoing actively right now a Fry hearing to determine whether or not it is scientifically reliable. And this bill wants to give money to a program that hasn't been proven scientifically reliable.
Wow.
Now, I've floated this argument to my wife, and she said, maybe you shouldn't say this. I'm going to still say it because it's something that I believe. There's been a lot of discussion in our country in recent months about defunding the police.
Mhm.
This is superfunding the police, and we know how superfunds work in New Jersey. I mean, we seriously do, and it's toxic. It really is. This is a toxic suggestion that we are going to fund a program that doesn't necessarily have any scientific reliability. We need to have there needs to be a basis, or we need to have some change in the paradigm for determination of intoxication and impairment, or we can't charge it, and we certainly can't use it as a reason to search somebody's vehicle, and to take away that person's Fourth Amendment rights against search and seizure. You have an expectation of privacy when you're driving on the road, especially if everything you're doing is legal. You have an expectation of privacy from having your car searched. This is saying that, well, that applies to everything except for marijuana.
Yeah, because he did at the end bring up, you can you can't drink a beer and drive. So no one's saying that you can operate a motor vehicle while under the influence. But what this bill does do is protect you and pretty much make the mere smell not grounds to search your car. So that's correct.
Well, what they're saying is that they can't search your car because they only believe that you have it.
Mhm.
They can search your car if they believe you're under the influence.
Gotcha.
Or you might be under the influence.
So
Now, that's a very subjective thing. A cop could be like, well, this person looks messed up, so therefore, and that's all he has to say. It's like, that's literally how far the inquiry has to go for reasonable articulable suspicion.
Gotcha. Thank you for that clear and concise breakdown and clarification. I know a lot of people are curious about this topic, but
as a side issue of this topic, and I'll just bring this up as one of my pet issues on this, and that is the dogs. I mean that we have police dogs out there that are trained to find a lot of different things. They can find guns, they can find all kinds of drugs, and yes, they include finding cannabis. Well, you can't teach an old dog new tricks. It's really comes right down to it. What do you do with those old dogs? I mean, the old dogs are either going to have improper hits, and that's going to create the ability, the reasonable articulable suspicion for a search, because it could be a gun, it could be cocaine. At that point, the dog can't tell you, why, yes, there is cocaine here, or this is marijuana. No, he just kind of barks or sits up, and deals with it. But you can't teach those old dogs new tricks. So what do you do with those dogs? And that's painful for a lot of those officers, because they get very attached to those dogs. They are canine officers, and they are considered, inline service members, and we have a lot of respect for them. I've made the suggestion, again, this is me and my practical look, and that's to move them to the Department of Education, because kids have no expectation of privacy in schools, and send them to the schools, let them look for all the drugs they want, at schools, and retrain new canine officers that won't trigger to marijuana. You can do that, but that's the new dog, new tricks. You can do that.
What a valid point too. That's something that, wasn't even on my radar, for all the dogs that have already been, trained in that respect. What happens to them? So that's actually that's wow.
That's not even on the legislation's radar, and that's not something that you can deal with as a regulator in rulemaking. That's not something that you can just throw funds at. As the Cannabis Regulatory Commission. You can't throw money at that. You can't solve that issue. And also, you can't determine what happens. Well, the dog sat up, it had a hit, we did a search, and all it revealed was marijuana. At that point, does that person have the right? Or it hits on marijuana and the person goes for a run, at that point, and because they're afraid, because honestly, interactions with the police are nerve-wracking, and I'm sure everybody who's done it knows about that. I mean, it is nerve-wracking. I mean, for anybody, even me. Anytime I've been pulled over, it's scary, and I know that it's got to be much, much worse for people of color and people who are different anyway, and especially people who might feel that the smell of marijuana is there. They might take a run. At that point, they wouldn't get charged with possession of marijuana, but they certainly would get charged for eluding or resisting.
Yeah, this is actually a great transition. So we were talking about tax and where tax revenue is going to go. So we know the funds based on A21, S21 will be allocated to cost to operate the legal program, state's law enforcement training, and the state's general fund. In terms of social justice, do you feel, so there was a lot of criticisms from the policy director of the ACLU. Do you feel that this piece of legislation hits the mark with social justice? 15% of the licenses will be given to women and veterans, 15% to minorities. Do you feel that this is satisfactory? What are your thoughts on the social justice aspect of this bill, and did it hit the mark? Is this the core of the bill, the core focus?
I don't know if it completely hits the mark, but it really does try. I mean, it's the first of these legalization bills that are actually working on that angle. The problem is that the numbers don't add up. I mean, I know that we've looked at in terms of the hemp program how many licenses there were, and that was the confusion that we had earlier with regard to there being 58 versus 28. The legislation indicates that there are only going to be 28 cultivators in the state, and these 15% and 35% that are set out in the bill aren't really easily divisible into 28. I mean, the 28 is not a number that goes in well. I mean, so it's going to be a really difficult, application process. I think that what the governor did to guarantee it, more than putting it in the bill and more than Scutari putting anything in the bill, is putting Diana 𝐌𝐢𝐜𝐻𝐿 as the chair of the Cannabis Regulatory Commission. She's been right on top of this since the beginning. She worked with ACLU. She has worked with 𝐼𝐜𝐼𝐜𝐿 Sinha of the ACLU quite directly about the big considerations about dealing with it. Now, we also have to worry about the use taxes and the other tax issues that come up. I mean, I can argue and get into the weeds of the tax problems, but one of the biggest issues that they have is more of a numbers question for me than a social justice question. Because you're trying to collect tax revenue and money when you have transfer fees. They're called taxes in places and fees in other places, but it's more there's 2% municipality wetting its beak. Let's call it what it is. The municipalities are allowed to wet their beak throughout the state. If they allow these certain cannabis businesses in their municipalities, those excises and abilities for use to those municipalities are going to be disproportionate. I mean, they're obviously going to be disproportionate. Where people can pay more, they're gonna get more. It's how property taxes create disproportionate school funding. I mean, it's always been the problem where the richer people get better things because they have better money in their municipality. It's difficult with that to come up with a solution, but one of the one of the ironies of this is that it's a lot of those rich communities that are banning the sale or cannabis sales in their municipalities, other than probably delivery services, which are going to be a real question, because you can't, because if I've banned it as a municipality, how can I then add a 2% tax if I have a ban on my as my ordinance? It doesn't, one doesn't add up to the other, and it's 2% that are staggered throughout the transfers. Like if you're transferring from a wholesaler to a retailer, there's a 2% transfer fee that goes to the municipality that the retailers.
So I'm sorry, I just wanted to clarify, because I'm not a legal expert, and I'm going to, is a transfer fee the same as a user fee? Is that the same terminology?
It's not passed on to the consumer, but it's going to be a cost on the, like, let's say if a wholesaler is selling a pound to a retailer, you know, or let's say the wholesaler has a pan of brownies that they're going to sell to a retailer who's going to sell 20 units, and those 20 units they're gonna charge them $1 a piece. Well, so they're gonna have $200 worth of spending. That's going to be $4 to that, potentially up to $4 to that incoming place for that transfer.
Gotcha.
Okay, and that goes from the growth to there, but they also are allowing vertically integrated, which means companies to have multiple different licenses throughout, especially the medical ones who are going to be grandfathered in and have multiple licenses at the same time. The problem is, what do you multiply that 2% by? You don't, where I'm giving it to myself, and I'm actually, going from seed to sale. How do I come up with that percentage of what goes to the municipality? There's no denominator, and it makes it extremely difficult to calculate. I'm a math guy, and that's and math and science guy, and for me to say it's difficult to calculate, I can't imagine somebody in a small municipality trying to figure out, what they should be getting paid and what they aren't getting paid.
Right, that makes sense. Thanks for clarifying that. And just to break this down for our viewers that weren't familiar with what's going on in the legislation for tax revenue, cannabis is going to be subject to a state sales tax. By my understanding, there's no excise tax, but municipalities will be potentially charging a local sales tax of 2%. So the fact that there's no excise tax, based on your legal opinion, do you feel that this will eliminate cross-border transportation if New York legalizes or other states legalize?
I think that the excise is going to be built into the price, unfortunately, because it's going to be a transfer fee. They didn't call it taxes, they called it fees.
Gotcha.
And the 2% fees are built in throughout. Now they're not necessary, and they're hidden really well in that bill. I got to say, they're you want to throw 95,000 words out there. They're not that the clearest words, but they're there. And it's 2% throughout all the little jumps that you'd see. I think that that Coughlin's suggestion that we add a user fee is kind of like adding 2% onto the end. That's really there's already 8% at least added onto the end from the seed to the sale, in terms of or a potential of 8. Those municipalities can enact a ordinance up to 2. They don't automatically get the 2. I've suggested that if they want to ban anything there, they shouldn't be able to get more than 1. I mean, if they want to ban a certain type of license in their municipality, they should be limited in how much they get from it. I mean, if you're going to open up. If you're going to close up, you don't get the benefit. But also give them a floor as well, because there are going to be these municipalities that either don't act, or can't act because they have political gridlock or something, and they're going to be entitled to something for the delivery fee, because the delivery percentage, that local tax, is based on where it's delivered, and there's a delivery system in the bill where they allow for cannabis to be delivered to your home. Now, that doesn't necessarily mean that that municipality hasn't banned it. They can ban sales in their municipality. They can't ban you from purchasing it from somebody in another town. But the Supreme Court of the United States, in a couple of different cases, has said that the taxes are collected where the purchase is completed. So, like where we used to have issues with wine, where you couldn't buy out of state wine. The reason was because you didn't know what the tax was. Should it be the tax from the state where it was created, or the tax where the state where it was received? The Supreme Court said it's the tax where it's received. Well, it's going to be the municipality where it's received. That's going to be where where that 2% local sales tax, is employed, and created, and the up to 2%. But if that's a municipality that's banned it, it seems antithetical to let them charge a full sales tax for something that that they have completely banned in their town.
Yeah, that's a good point.
So I've had issues with that from the first time it was suggested, but but you could see from the licensing structure there are so many different levels of licensing that they tried to create in this that those transfers between those licensees are going to be where the state collects a lot of those transfer fees and where a lot of the money is made, and that is going to be passed on to the consumer. Don't kid yourself. That's not something that that's a cost of doing business that somebody's going to say is something that
Wanted to focus on your specific criticisms of the bill, because I was reading your testimony and you have some very, very interesting points that you brought up. But before we get into that, I wanted to play just one quick clip of Senator Paul Sarlo of Bergen County, and he brings up
the home growth
concerns about employment. So,
the employment, yeah.
As a New Jersey medical marijuana patient, we didn't see employment protections until
Honeck.
A medical expansion bill, which was two Julys ago, so 2 summers ago.
Yeah.
And still, if you are working for a company that deals with federal funding, you're not protected, and you're also not protected to use cannabis at work. So
I will be 100% honest. This is not my biggest area of expertise, but
okay.
I can speak to it to a relative level of competence.
Sure. Yeah, and also just getting your reaction. So here's
Yeah.
Senator Sarlo, and he's going to bring up a concern here with the legislation.
There are going to be employees who, are they protected? Are they going to lose their job if you are working for a utility company and you get tested after being at a weekend party or at a weekend gathering or in your home, and during the week you're tested, you're not impaired or high, but it's in your system. You have violated that drug policy, and under regulated utilities, you have violated and you're subject to being dismissed from that employee. There's nowhere in this legislation that makes it clear. I'm going to let David read you the part. I read the part.
There's another section that's just above in section 45 that I think may be speaking to at least part of your concern. It's on page 160. So section B, it says the presence of cannabinoid metabolites in the bodily fluids of a person engaged in conduct permitted under the bill. And it goes on to say, with respect to a student, employer, tenant, shall not form the basis for refusal to enroll or employ or lease or otherwise penalize that person.
But that conflicts with what you're saying. That completely conflicts with 46B, where it says it does not preempt the rights and obligations of employers to retain a drug and alcohol-free workplace. That conflict, because If you work for a regulated utility, they're saying you can never have it in your system. And up here, you're saying it's okay to have it in your system and you can't lose your job. So we have a conflict there, 45 and 46 conflict.
Senator Sarlo's criticism seems to come with detecting and determining which employment has a rational basis. They created a rational basis test here that an employer can opt out of requiring or of allowing somebody to consume and have a prohibition against consuming if there is a rational basis to their employment. The problem with that comes to, you know, the presence versus impairment issue. And like I've mentioned in the legal in the criminal context, you know, in terms of that, there's a much higher standard for of, you know, beyond a reasonable doubt were you under the influence. But in the employment context, you're more as a beyond the preponderance of the evidence. So therefore, you have a lot lower standard. You have employers who are going to be left with, well, I don't know if this person is just having a bad day or they're high. And I mean, you know, it's like, but they can use it at home 30 days before and still test positive, you know, under the best testing that we have, and they can say that that's a violation of their policies and a basis to test them. I think that while Senator Sarlo's concerns about safety in the workplace are justified, I think that they're difficult to enforce because you can't really determine acute intoxication. We don't have testing for that. As I mentioned earlier, you don't have testing for acute intoxication, so you can't really determine if somebody is under the influence at that exact moment. What you may be able to do, and I know that certain of the scientific testing is out there that can do buccal swabs that can tell if you've consumed within the last 24 hours, but still, if you're going to work on Monday and you're having a rough day, you know, you had a weekend before you, you know, you're allowed to do that. And especially as medical patients, if I'm on a medication, if there's no rational basis to safety for me, if I'm going to be a chairborne ranger and sitting behind a desk all day, you know, doing my work, you know, it's like, why do I need to not have any kind of cannabis in my system? You know, when I go home and enjoy a perfectly legal product, it would be the same if I go home and have a scotch. You know, it's that's not prohibited. It's not, you know, it's frankly encouraged by some employers.
Yeah, and that's a good point, you know, with the specific, because I know with Senator Sarlo, he was bringing up specific examples, and he kept bringing up, if you work for a regulated utility company for the state, that's you're subject to routine testing, you know, who is held liable? And he basically, what I'm asking, do you agree that the language is not strong enough? Is there an implication for employees? Do you feel that language is strong enough, or is that something that they're probably going to continue to tighten up?
I think they're going to have to tighten it up, but I think it's one of those things where they could, in fact, technically loosen it up and give it to the CRC for regulation. Okay. And, you know, and have the CRC work on regulation of it. I think one of the more interesting ones, instead of regulated utilities, I'm going to go to a completely different area that I know a little bit more about, not from myself, but from my marriage. And my wife used to work and still works has worked in group homes and with people with developmental disabilities. And they passed a couple of years ago Comninos law, which has a state regulated and mandated responsibility for developmentally disabled caretakers to be pre-employment tested for marijuana, and that's a disqualifier for that type of position. Now, I mean, it came from a horrible case. I know that a lot of the emails you've seen me send out also include a Jason 𝐻𝐸𝐚. He serves on my committee in the municipal court section. He's my chair-elect of that section, and it was his brother who passed away as a result of a caregiver who was under the influence and driving and
Jeez.
caused his brother to pass away. Now, that being said, I understand that there's a rational basis of people who are driving for a living really shouldn't be under the influence. I mean, we all agree with that. There's nobody on any side of this debate that's going to suggest that that's not something that's within an employer's level of concern and an area and concept of concern. Where it's going to end up being questionable is, well, first of all, how do you change 𝐻𝐸𝐚's law? Because I mean, you have the state testing for people whether or not they're under the influence, and the state refusing to allow people to work in that industry who have tested positive, even if they are medical cannabis patients, even if they are people who would just be going to homes and working within group homes and not having any kind of car, automobile related functionality. There's questionable rational basis, but there's still 𝐻𝐸𝐚's law out there. So there are certain laws that are out there. If Sarlo has an interest with the issues regarding public utility workers, he can probably write a special law like 𝐻𝐸𝐚's law to deal with it. And I don't see him not doing that.
Yeah.
I mean, but I could see that the rational basis questions are definitely interesting, but they are going to be directly and more appropriately tied to determinations of the science and acute intoxication determinations. If DRE is found to be a scientifically viable alternative, even though a lot of my colleagues and the State Bar Association have filed amicus briefs saying that it's junk science. If it's found to be scientifically reliable, at that point you could use a drug recognition evaluator that's gone through the program and could say this person is under the influence, they should not be operating. I think in general, when it comes to those types of things, we really need to change our paradigm, even from drunk driving and driving under the influence, because we need to really take a different look at the paradigm and say people shouldn't be driving when they shouldn't be driving. I mean, if you're upset, if you're texting, if you're if your kids are throwing things at the back of your head, you shouldn't be driving.
Yeah, you're tired. Yeah.
If you're tired, exactly. And it's almost impossible for us to test for that. But I've also been published on this question, and I say that, well, within 5 to 10 years, it's not going to matter because we're going to have autonomous vehicles, and we're not going to need to worry about it. But, I mean, it's like if we supported autonomous vehicles and went toward that direction, we wouldn't need to worry about this. But you would still need to worry about it in those public utilities, or even in warehouses where you need to do pallet jacks and things like that. And forklifts, those people who are driving around in those really shouldn't be under the influence of anything either. But they also shouldn't be looking at their cell phone, and they also shouldn't be upset or tired.
Tired, absolutely. Definitely, these are valid points, and again, your wealth of knowledge. One of the other criticisms of the bill, or of A21S21, and this is something that resonates with me because I am a medical marijuana patient. What are your thoughts on home grow? Is this something that we will ever see in New Jersey? And do you agree with 𝐸𝐻𝐻𝐿? So 𝐸𝐻𝐻𝐿, his stance is, and this is quote, if you allow people to grow their own, why would people apply for licenses? you will supply an additional level to the black market. Do you think home grow will give a reason for the medical marijuana program to still exist, or do you think that it's still going to fuel the alternative market?
Well, I think that the more interesting testimony on that was in the assembly version, or the assembly hearing on this, and they mentioned that one of the guys mentioned, the co-chairs mentioned that he brews his own wine and beer at home. These are people who, there's a certain amount of home brew that's allowed for alcohol. But what he said is very telling, and that is, I still go out and I purchase. I still go out and buy beers that I like. I still, I don't sell my wine. I have it for my own consumption and for other people's consumption. I don't necessarily agree with Nick on that there's a necessarily a need to stop home grow, and I don't necessarily believe that the bill as written in compilation with the constitutional amendment prohibits home grow. I honestly believe that everything that makes us the garden state suggests that we're going to grow a lot. You don't grow your food for the entire nation in the garden. You grow the things that you want for your own consumption. You grow, you grow your corn, your tomatoes, the things that you like in your garden that your family's going to eat. Well, you're also going to grow your cannabis, your marijuana, and what you like. And yeah, it's going to cost you quite a bit, because it does. And these businesses are also hopefully going to be able to make money off of the ability to sell clones and that market. And that market's going to have to be regulated in terms of what they're buying and what they can expect in terms of yields and also percentages, because we need to know what we're putting in our bodies. And if you're growing it at home, I mean, if I'm making homemade wine, I want to know that I'm not distilling it and creating 100 proof 100 proof wine, so that when I drink it, I'm completely messed up. No, I mean, I want to know what I'm consuming, and that's one of my biggest issues against decriminalization and in general has always been that you don't know what you're putting in your body if it's not subject to testing and regulation. And you should know what you're putting in your body, whatever it is. I mean, and understand the effects that it's going to have on you. I mean, there's several different people who have several different effects from things. But when I pick up a beer bottle, I know it's going to have something that has 18, at max 18% alcohol. I'm not going to drink Everclear.
And that's a valid point. So, and I am a person that's a staunch supporter of home grow, just because, as a patient, I'm waiting in the lines. We have a handful of dispensaries, and we've had a program since 2010, and we still haven't seen the dispensaries open because they're caught up in a legal battle.
Unfortunately, I've been a part of that as a little bit, but not directly. I've been indirectly a part of that, but I know about it enough.
You're familiar.
Very.
So I definitely I support home grow, but that is a valid point. Testing. If you are growing at home, how do you truly know how much THC or CBD or CBG is in it? Then we're going to be bringing our cannabis that we grow at home to labs. So that does bring up a point, like for patients that would be growing at home is the testing aspect.
The alternative solution there is that you would know from the experiences of the previous growers, if it's a clone, what type you're buying. I mean, and what type of yields that particular crop has had. I mean, yeah, you might have additional environmental stressors on the plant at your home and in your home grow, but it's still, you're going to have a relatively comparable product. I mean, if I'm making wine out of a certain type of grapes, I know basically, where the float is. I know what the alcohol content is. from certain areas of grows, and as long as you get good education from one of the growers, you would know basically what the yields would be, and what the THC percentages and the CBD percentages, and all of the other, and the terpene percentages that would normally be there. Or you could have those laboratories that are going to be set up throughout the state available for testing of your homegrown product. That's and that would be an external revenue source for them, which obviously they would welcome. unless they're slammed, which they very well may be if there aren't enough of them.
True. So that brings me to transitioning into your criticisms of the legislation. And you brought up some really, really interesting points. And one of them, and I hope I'm saying this correctly. So
the last one I'm guessing that we haven't mentioned is the property tax issue. The fact that you can't grow it on farmland.
Yes, that's a thing. So you cannot.
That's a thing.
That's a thing. On preserved, if it's considered preserved farmland in New Jersey.
If it's taxed as farmland.
Taxed as farmland.
Now, I honestly, I don't know much about you guys. I don't know where you live. I live down in Vineland. Vineland is the largest city and area in the state of New Jersey. We are 64 square miles. We are not that populated, so you can imagine the amount of farmland around here, and there's lots of land. And the property taxes are less. It's anywhere between $40 and $80 an acre that you pay on a farmland assessment. This bill doesn't allow you to grow on farmland. It doesn't allow you to grow a crop, to grow a crop on farmland, a specific crop. Now, as I've argued, and as we've presented numerous times, that's against. It's unconstitutional under the New Jersey Constitution.
Why would he put that? Why would this be in there for? Why is that something that even exists in this bill?
The League of Municipalities.
Mm-hmm.
They are trying to get property tax revenues for the municipalities out of this, and to get these grows to be done in commercial properties, so that commercial properties can be rebuilt, so that inner city commercial properties particularly can be rebuilt by that's where you would do it, versus doing it in farmland or on open spaces. And certainly I think that the most ridiculous part of it is where we pay to preserve farmland in New Jersey. We have the farmland preservation that we do. This does not allow you to grow on preserved farmland. So we're paying for you not to grow this crop, this potential crop on your property. We're treating one crop differently, and we're treating land differently because of what we grow upon it. And that's never been allowed in New Jersey. You've never been able to say, well, you're growing tomatoes, so you're taxed at $100 an acre. You're growing, it's unconstitutional, and it's just wrong. And it's wrong-headed from an agricultural standpoint as well, because you need to be able to rotate crops. You don't want to wear out soils. You don't want to wear out, areas where you're going to be growing. So you're going to want to rotate crops and have different crops in different areas. If you're just planting in a small area and you're only given a certain amount of canopy space under this legislation, you're going to be planting those things tight together, and everything's going to be, you're going to be tearing the hell out of that soil. I mean, it's going to be rough on those. Or if you're not doing it in soil, you're going to be creating huge amounts of environmental waste that are going to be created in urban areas that are not going to be expecting it in their sewers. Like to throw that kind of those kind of, not necessarily pesticides, but because you're going to have limited pesticides, I'm sure, but that kind of the fertilization that you'd need to grow that, and the liquid fertilization, even in drip irrigation, you're going to create huge amounts of environmental impacts that are going to be that are not even being considered, and they're adding them to urban areas, of course, where there are higher concentrations of people of color, so that they care less about those areas. So that's perfect for them. It's that vicious cycle of problems that come with the unintended racism that's in our society that we don't even see. You wouldn't see something like a property tax question being a race question. But if you peel away the onion, you just kind of say, okay, you want to grow it in downtown, Trenton versus out in the boonies. It's like, well, why would we want to do that? It's like, because you want to protect environmentally and also reduce the cost on the municipal utilities, that are going to be taken from having grow lights all over the place and in those places.
Wow.
I mean, there's so many different impacts that they're not that need to be balanced. And it's when you take something that's that simple of you grow farms in farms. And I mean, I hate to be just, make it that simple, but it's like farmland is farmland is farmland. You grow a crop. Marijuana is a crop. Cannabis is a crop. You plant a seed in the ground, it grows. There's no way to consider that non-agricultural.
Yeah,
There's
we've been there for thousands of years across.
and you know what? We tax alcohol differently. We do. But we do not tax the land that the grapes are grown on differently. Even though they're wineries and they're vineyards, we know exactly what they're growing there. They're not taxed differently.
Yeah.
But this crop is different for some reason. And there's no reason behind it other than it's a money grab. And it's 100 times more, it's a potential 100 times more tax that they're going to create, that they're going to collect for that property. And they're going to collect it from urban areas that aren't going to be able to support them. Whereas, the rural areas could support it and could support, crop rotation and could support, other uses of farmland. And also, I mean, we don't want pollinated crops, but, at least somewhat infused. I mean, you could see that there would, if you grew it next to tomatoes, there might be a benefit to the tomatoes. I've heard of a couple of my farmer friends who want to feed it to their chickens and see if they can get THC infused eggs, and I mean, there are people out there who want to do that kind of thing and see what happens. I think that's a great idea. Let's do that. Let's encourage that, in the agricultural centers, and not encourage urban grow. It's got to be rural, and the rural areas have been hit pretty hard in the state of New Jersey. I mean, down near me, the biggest industry is prisons. So
Wow.
So it shouldn't be.
Yeah.
It shouldn't be. And Weedman's right. You gotta before you have the first legal sale, those people need to be out of jail who are in the jail for it.
Absolutely.
And that's got to be the first consideration. And that, if you want to talk about racial justice, if you want to talk about social justice, that's where you start. It's like, let's end the drug war, and let's not make money off of the poorest people's backs, and not make money to the detriment of the poorest people. The people in the farmland and the people in the inner city. Because you see, the two places that I mentioned that are where it's going to grow are obviously the places where the poorest people are.
Absolutely.
Yeah.
So for now, when that eventually happens, we're going to have discussions about how far away marijuana cultivators can be in farm country near hemp farmers, because we saw out in Colorado and Oregon, close operations of the two cousins could cause cross-contamination, cross-pollination. And then since hemp farmers are so sensitive to the THC count, that could cause, having a marijuana crop close to their operation could cause them to test hot and thus ruin their crop.
That's a good point. And Michael, let me ask you this. Is there anything similar in hemp legislation with a tax like this, or is this just unique to the marijuana legalization legislation?
Well, in the hemp legalization, because there's no restriction on the Federal Farm Act, they do not require, or they don't restrict the hemp grows on from farmland and from qualified farmland, but they obviously have to maintain it under the requirements of the Hemp Farming Act and under the New Jersey hemp requirements under the Department of Agriculture. I mean, you guys know about those, so I'm not gonna try to jam those down your throat. But they don't have those same requirements on that. They didn't add that little wrinkle in, and they added that wrinkle in 2703 about the property tax and not allowing for qualified farmland. And we raised the issue as the State Bar Association last year, and it didn't go anywhere because obviously it's still in this one. And that was something that the League of Municipalities raised as their big issue in both of the committees, that they wanted to make sure that this was, that right to farm was not included as well. It's like, well, that's,
and we follow a lot of, advocates and people that work in the industry, and you're the first person and only one to bring this up. So I feel like this is really great that we have you on tonight. And
I honestly think it's one of the, I was told at the beginning when I was considering it that one of the, that I was being a little bit naive about the plant. When I initially brought up, it's like that they should allow for, outdoor grows. And it's like, because you've got to avoid pollination is what I was end up told. But you can do that with greenhousing. I mean, you can do that in outdoor grows with greenhousing, or tarps, or domes and stuff like that. You can do that on outdoor grows without having permanent fixtures and creating permanent things that say, there are ways around it, and they need to really consider what New Jersey is and how New Jersey looks at this type of thing, and how we've always looked at it from our laws and from our Constitution, what it makes us. We are the garden state. We grow, and we are Jersey fresh, and all those other things. Allow the home grow. That would be great. But it's like, don't restrict the home grow. It's like, don't restrict somebody from growing a crop on their land. It's like that's just ridiculous. It should be common sense. It absolutely should be common sense. I mean, yes, you will need a cultivator license to be able to grow it on that land, and that will require the licensing and all the other, other happy stuff that they need. But the three of the impact zones that were identified and would continue through 2703 and would continue in S21 and A21 would be Vineland, Millville, and Bridgeton. There are 3 municipalities of the 40 that would be considered, including Trenton and Camden and Newark, and all of those, those places where there have been disproportionate problems with marijuana arrests, convictions, and effects. That's why the biggest problem I had when we were advocating last year was I went to go talk to my local state senator, and he was a Democrat, but he was staunchly opposed. And I went to meet with him, and I'm like, I don't meet with senators. That's not me. It was never me before this issue. It was never me. I wasn't the guy who was going out there to advocate for anything other than a client. It's like I would go to a court and advocate for a client. I wouldn't go and advocate for an issue. And I went there and I asked him, I was like, why are you doing this? And you know, the answers that he gave me were totally wrong, to the point where I couldn't, being a Democrat, I couldn't vote, I couldn't even vote for my Democratic candidate. You know, it's like, and I couldn't vote for the Republican candidate either, you know, for a lot of different reasons. And me and him have known each other since high school and before.
Yeah.
Yeah. But he's staunchly opposed, and but he voted today in favor of the decrim bill. So I want to find out. I want to make sure that he actually did, because it went through his committee today, Senator Testa.
Oh, okay. Yeah, we'll have to
Yeah, because he's in Senate Appropriations.
follow up with that.
Yeah, because I didn't know until right before I got on with you guys that had gone through. And one of the other things that, you know, maybe we should throw up the red sparks about, you know, sorry, my Harry Potter is, you know, tingling a little bit, but you know, throw up the red sparks about, but that they threw in psilocybin in the new decrim bill. They threw it in. Just, you know, it's like they didn't make it decrim, but they made it. They said they would move it to a 4th degree offense, or it's a disorderly persons offense. So it could be dealt with in municipal court, and you could have a certain amount on you at certain points.
This is also news to me as well.
Yeah,
where would have been dealt with other than municipal court prior?
It is, until that passes, it is still a 3rd degree offense. It is subject to 5 to 10 years in prison for possession of psilocybin.
Wow.
And
Talked about.
They hadn't talked about it until this afternoon. It didn't get. It was added by amendment this afternoon. I mean, this is how fast this thing is moving. And honestly, there are a lot of people who are saying that's a poison pill potentially to the legislation. I think they might be right, but it's also potentially a bargaining chip that they added to take away. I mean, you know, it's like I don't know what the concept is of adding something that really, you know, is outside of it and taking away from the conversations that we really need to have about cannabis by adding, you know, by adding the psilocybin question. I mean, it's a valid question. I mean, there is medical usage for it, and there's a lot of you know, evidence about the medical benefits of psilocybin, but it's also a Schedule I controlled dangerous substance. So you gotta have that concern. I mean, and you know, hypnotics are a lot different than cannabis, and you can't just start lumping them in together, because you know we're you know, if we get lumped together, we die together. And that's not something that we want. It's like this is what the voters voted on. This is what New Jersey wants. You don't want to add too much to that. So the psilocybin question, I'm not sure how I feel about it yet. Yeah. I don't think it belongs in front of the CRC. That's for sure. I mean, the Cannabis Regulatory Commission should not be regulating, you know, magic mushrooms. I mean, that's just not something that belongs there. It's kind of like, you know, having us also deal with, having ABC deal with it, the Alcoholic Beverage Commission.
Well, you heard it here, folks. Heard it here first, folks. For those of you that don't know, the psilocybin question is also a part of our legalization conversation. So that's news to me. Very interesting. And I feel that deserves an entire other. I feel like we need a part 2.
You know what? I can make recommendations for who is better to talk about psilocybin. That's not my area. You know, like I said, when it comes to labor, not my best labor law. I think to be smart, you need to know what you're good at and what you're not good at. I think, I'm good at what I'm good at, and that is definitely the criminal procedure stuff and a lot of the science that's behind these pieces of legislation. I understand it, and to a certain extent, I can do the math and understand the property tax issues and the excise fees and those things. I can see them. I can see how they work. When it comes to questions on psilocybin, yeah, I get a little bit uncomfortable. It's out of my comfort zone. When it comes to employment law, I get out of my comfort zone. You know, there are certain things that I'm good at, certain things I'm not. Those two are areas that I'm not. And I know that Joe Shapiro is a big advocate for psilocybin, and he would be a good person to talk to about psilocybin and the addition of that on your next one.
Well, thanks for that recommendation.
Yeah,
And,
Joe's a stud.
Yeah.
Very sharp guy.
Agreed. I've worked with him on a couple of different things with regard to this, and he was one of the first people who ever brought up that, you know, psilocybin's the next step. And, you know, considering what Oregon did, considering what DC did, yeah, I can see that that's the next step. I just don't think that we should stumble because we're trying to take too many steps at the same time. New Jersey moves a lot slower than a lot of those other states. I mean, we're trying to be ahead. We're trying to do it right, and
Right.
we can see a lot of the mistakes that other states have made. I think that that's one of the best things that we've learned. You know, and when we were talking about the tax question, the sales tax question, I think that having the same sales tax on it as everything else is brilliant. They weren't going to do that in 2703. They were going to do an amount per ounce or something like that Murphy wanted, and it was going to be taxed high. And I always brought up the issue with regard to the state of Washington when they had a certain tax rate and then they cut it in half and got the same tax revenue. I mean, because people went back to the legal market. I mean, and as much as I might disagree with Weed Man about the way he goes about things, one of the things that I have to say about home grow and about regulated grows and regulated sales is that we're right now about 70, 80 years after, you know, we got rid of alcohol prohibition. You don't see people having rock gut gin anymore. You have everybody who's consuming alcohol is doing it from a regulated, known place. Well, that's what we need to consider that the cannabis marketplace is going to look like, or should look like, is that, you know, either you're going to do these quality home brews that are going to be, or quality home grows that are going to be people's own, you know, creations and their labors of love, or you're going to have people who are going to purchase it on the legal market, and create that legal, safe, and regulated market for everybody to use it. That's always been my position on it, and I'm not even a consumer in the market, legal or otherwise. You know, I'm not a consumer. I'm just a concerned person.